All right. Well, of course, we're 7 minutes into this nonsense, and we are still waiting on the boys and girls at the State House to figure out that it's time to get to work. They're still spending time in the little boys and girls room. So, who here has heard about Amendment 14? Amendment 14, ladies and gentlemen. The amendment allegedly telling Indiana that reserves are in fact trained. Oh my God. Who knew? What a laughable mess. I don't know how long today's meeting. Well, I can give you a little bit of an idea. Hold on. Give me 1 second. I'll tell you about what we're looking at today, time-wise. I'll tell you, ladies and gentlemen, the other thing that you need to be mad about, the other thing that you guys need to be mad about is what's going on with Senate Bill 1. I don't know if you guys have heard or not, but property tax plan that Braun was going to make sure got done. Well, it was gutted yesterday. And so tonight at 9 p.m. Eastern, right here on the Political Spotlight, we are going to do a full look at the nonsense going on at the State House in the last couple of days. We're going to be looking at Senate Bill 01, of course. That's the Braun property tax plan. We're going to look at what happened yesterday and why it was gutted and what all happened. Then we're also going to be looking at House Bill 1628. That was in committee yesterday, and that's a property matters bill where the state is looking to take local control away from local governments and put it at the state level. They want the state to tell people up in Valparaiso what's best for their community. They think that Indianapolis should be able to tell Evansville what's best for Evansville. They don't want to leave local control to the county council and the county commissioners when it comes to industrial solar and industrial wind. And so that's that bill, 1628. We'll be talking about that tonight. And then, of course, we'll be talking about this bill that we're all here for, which, of course, is House Bill 1186. And we'll be talking about what goes on in this committee, as well as what my thoughts are on this and what's happening. Of course, we don't know what's going to happen in this committee meeting. They may vote. They may not vote. It might die. It might not. Who knows? I mean, I feel like we all have an understanding of what's going to happen. I do have to give a big shout out.
Good morning. I
Elias
see a quorum,
Belter,
and welcome
he's
to
been
Courts
down
and
there
Criminal
working,
Code.
and that's awesome. So, all right, we're going to start.
Everybody's slowly coming in here. If you have not signed up to testify, please do so online, or there are paper, but I prefer online. We are going to go in reverse order today. From the bottom up. And with that, start with Representative Bauer, if you'd like to introduce yourself.
Hello, I'm Representative Bauer from House District 6 in South Bend.
Go ahead, Representative Shackelford.
Representative Shackelford, House District 98, Marion County.
Good morning, Madam Chair. I'm Mitch Gore.
Oh, reverse order.
Matt Pierce, District 61, which is most of the city of Bloomington.
Joanna King, District 49, Elkhart County.
Alex Zimmerman, House District 67, parts of Decatur, Jefferson, Jennings, and Ripley counties.
Jenny Meltzer, District 73, a part of Decatur, Shelby, Bartholomew, and Jennings counties. Andy Hedges, I'm the attorney for the committee.
Garrett Bascom, House District 68, Dearborn, Ohio, Switzerland, and Jefferson County, a tiny portion of.
Steve Bartels, District 74, Southern Indiana.
Chris Jeter, House District 88, portions of Hamilton, Hancock, Madison, Marion counties.
Come on now. I don't know why it always does this.
6.
There we go.
Thank you, Madam Chair and members of the committee. So looking at amendment number 12,
Here we go.
the first part of that amendment actually removes the enhancement penalties for the highway workers section. When we get down to about line 5, this is where we want to clarify some issues for law enforcement that have been brought up over the last couple of weeks. So we want to make sure that if you were a law enforcement officer, regardless of their training, is dispatched outside their jurisdiction, or if they're responding to an officer's call for assistance, and then trying to also address this issue of backup. I can't speak for all officers, but I have experience that a lot of times we would go outside of our district just to drive by another officer's call, whether on a traffic stop or at a residence, just to show a police presence. So we want to make sure there's no penalty for operating outside your jurisdiction for backup. There was concerns with the Marshal Association reference to qualified immunity. We want to make sure we clarified that if you're operating with these exemptions, you still have the qualified immunity. So we made sure we put that in there. Going more towards the back part of the bill, there was an issue of raising the Class B misdemeanor to a Class A for criminal recklessness. We went ahead and left that in there, but we did change all the rest of the penalties when it comes to the issues of shooting and pointing a firearm from a vehicle. So you can see there that we actually added the words under a level 5 felony that if you're shooting a firearm from into an occupied motor vehicle, it would be a level 5 felony. We also make sure we capture kind of the big problem here is if you're a passenger in the vehicle. So we want to make sure the passenger is also subject to the same level 5 and level 6 felonies, even though they're not operating the vehicle. So we kind of cleared that up, and that is the basis of the amendment. Answer any questions.
Any questions for Representative Bartels? Okay. Can we take the amendment by consent? Okay. And I want to remind you, I think we've already approved amendment number 7 and number 9. Okay.
Madam Chair.
Yes, sir.
I'd just like to clarify that when we took number 7, and we'll be fixing this later, but the intent here was to allow SROs to actually chase fleeing subjects, but more importantly, we did not inherently fix it in the criminal code where they're exempt from doing that. So I just wanted the committee to know that it's an oversight, and I'll be fixing on a second reading amendment.
Okay. Any questions about that? All right. Any other questions, comments for this particular bill? Okay. Can I have a motion, please?
Move to pass as amended.
Second.
Okay. Take a vote, please.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
Yes.
Representative Pierce,
Yes.
Representative Shackelford,
Yes.
Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald. Representative King,
Yes.
Representative Bartels.
Yes.
We're going to hold that open. Should Representative Sturwald reappear? And then I will let you know what the final count is. House Bill 1602, Representative Culp.
There we go, ladies and gentlemen.
Oh, he's in another committee.
It was just voted.
There we go. You're up.
Thank you, Madam Chairwoman, members of the committee. House Bill 1602 is a food bill. It has 3 parts to it. I'll just briefly go through those and we can get to the amendment. It's a food labeling bill, first and foremost. If it is a plant or cell-based product, it just says that it has to be marked as such. Representative Baird had a bill that was similar, but yet this is in the Department of Health side. His was in the Board of Animal Health side. It also establishes an appeal process. If you're a local food establishment, you get inspected by your local health department's food inspector. You disagree with their findings. It's a two-step appeal process. First to the county health board. Secondly, if you disagree with their findings, to the local legislative body, which would be the county commissioners. The bill also talks about it clarifies the custom exempt status of if you go take a animal, you buy an animal from a farmer, you go directly to the state inspected processing plant. If you buy the whole or a half, if you buy the carcass, then you get a custom exempt stamp. But if you can't afford to buy that much, or if you don't have freezer space for that, current law does not allow you to buy a portion of that by the package. This would clarify that and bring consistency through that as well. So the amendment, again, establishes that appeal process. It clarifies the custom exempt status as well. And that's really a highlight of what the amendment does to the original bill, which did pass out of the House Ag Committee unanimously.
Any questions for Representative Culp? Representative Pierce?
Yeah, I'll start with a general question and get more down to the bill a little bit more. So my general default position is more information to consumers better. So I agree with the intent of the bill there. But I'm just wondering, over the years, we've had these battles about like oleomargarine being portrayed as butter, or for a long time, there were discussions about whether any genetically modified organisms used in food production needed to be labeled. And I know there's a lot of pushback on that. So I'm just wondering kind of what is your general philosophy of when a consumer needs to be informed about something versus when maybe it's not that important?
Sure. Well, this came to me from a constituent. So people say, well, why aren't you including milk or eggs or other products? Well, it's very narrowly focused on meat, and it's patterned after the Iowa law. The statute is what the LSA drafter took into consideration. So we think consumers should know what they're buying and what they're consuming. When you look at a meat case, and that's where this would be at, a meat case, there's a lot of options. And I think it's just important to know if you want to buy an imitation protein, you should just be aware of that. And so we're not exempting them. We're not saying that's prohibited. We're just saying that labeling would really be important to that. So that's kind of the general thought behind that.
Okay, thank you. And if I could ask about the penalties. So I guess the State Department, if you're on Section 6 of the bill, it's on page 9. I'm just trying to make sure I understand how this is working. So you get a civil penalty if you violate Section 1, which is misbranding, right? So you could be fined up to $10,000 if you're basically selling stuff that's portrayed as real meat when it's actually imitation. Am I understanding that correctly?
If it's misbranded or not branded at all, if it is an imitation product and doesn't turn that label, yes, then you would be eligible for that violation, for that penalty.
So the state health department could fine you up to $10,000 for violating there. And then I guess what I'm understanding is then we have a second penalty, I think for the same thing, where if you recklessly violate it, then you get a Class B misdemeanor. So is it kind of an either or? The State Department could just do a fine, or the local prosecutor could say.
So one small change here: the word recklessly is being amended to knowingly or intentionally, to try to clarify that. There was some concern about, and again, these are retail food establishments, which could be a mobile retail food establishment or a permanent based one. The drafter, and I've talked to the drafter about this, and he felt like this was consistent with what we currently have in penalties. And so he was just trying to add consistency to this new chapter.
Okay. So I guess what I'm trying to figure out is if we have the same bad act, mislabeling or not labeling food as required under this bill, the State Department can either civilly pursue you and fine you up to $10,000, or the local prosecutor, if I'm understanding this correctly, if he can show that you knowingly and intentionally violated that, then he can prosecute you for a Class B misdemeanor. Am I understanding that correctly?
Correct.
So it's going to be an either or, maybe both?
it's possible if the state took action and the county took action. Yes.
Okay. And then finally, so then in subsection B, it says each day a violation continues constitutes a separate offense. Does that mean if I'm selling this meat for a week before someone figures it out and then charges brought, that you could be charged with 7 Class B misdemeanors because
Well-
each day would be a separate offense?
Well, following the notification of infraction. So if it's mislabeled and nobody is questioning that, I mean, you can't go backwards. Once it's discovered, you can't say, you've had this on the shelf for 10 days. We're gonna fine you for 10 days. It would be that day going forward from the violation you'd be notified of the violation.
Okay, I'm not actually seeing that in the statute. So the lawyer in me is thinking that if you can show that someone knowingly or intentionally sold the stuff over multiple days without properly labeling it, it seems to me that would just be separate offenses. So I don't see the language that gets to that, how you've described it. I don't know if I'm missing something, but
I'm standing in front of a group of attorneys, so you're more qualified to
okay.
to
So I don't know.
to address that than I am. So.
Right. So, I mean, I want to apologize. I'm going to blame Representative Soliday because he had these huge bills and utilities and meetings that went on forever. So otherwise, I would have attempted to prepare some kind of amendment or talk to you about how maybe I think we could. Let me just say that I think that is an issue about multiple violations over multiple days. You could really stack some stuff up and maybe end up being disproportionate. But I think the other thing is that when we did criminal code reform back like 11 years ago now, one of the things that we kind of, I think, concluded is oftentimes instead of doing misdemeanors and this kind of stuff, it's better to do infractions with these financial penalties. So the idea is that if people are marketing this stuff to make money, if you take away their profit and actually cost them a lot of money, that might be a more effective deterrent and not have people rolling through the criminal, end up in jail or whatever. It might have the same deterrent effect, but not have somebody using up our resources of jail. So I just throw that idea out for consideration.
Your point's well taken. I'm certainly willing to continue the discussions. Thank you.
Representative Pierce, in consultation with Andy next to me, probably would be best like line 23, section 8, after notice of a hearing of compliance, that should precede or something like that prior to section 7. That way that, I mean, we're not going to fix it with a chairman's amendment, but I think something like that might resolve your concerns on that particular section. That way that there's a guarantee of a notice prior to the continuous things. Would that work for you?
I think that would be an improvement. So what we're basically saying is you're not going to be exposed to the B misdemeanor unless you were basically warned or like, hey, you're not following the law, and then they just don't care and keep doing it. And I guess prior to that, you would still be open to that fine, even.
Are you okay with that if we do on a second reading?
Yeah, I think so. We might want to talk a little bit more just about the nuances of it, but yeah, that general thing works. Thanks.
All right. Representative Bartels.
Thank you, Madam Chair. More of a kind of a statement looking at this as we're continuously considering fixing things. It doesn't seem like the producer or packager has any liability. Is there, am I missing something on this, or can we add that? Or
that's included in Representative Baird's bill. So his is on the front end at the packaging. Mine is on the retail end. And so that's why we separated those bills. There were a few things we had to merge together so they were not in conflict with each other. Mine is in section code 16, which is local health department. His is in code 15, which is Board of Animal Health. And so we decided to keep confusion out, to separate those out. So that's how I would respond to that is they would be liable to those penalties at that labeling end.
One follow-up. So if they both don't get across the finish line, we're going to have some kind of ability to fix it, I guess. Okay.
I would say that's correct. Yes.
All right, any other questions? Representative King.
Thank you, Chairman. Thank you, Representative Culp. You and I had some great discussion on the exact same section that Representative Pierce was talking about. I still am a little concerned that mobile retail food establishments, people that are not in the process of labeling anything at all, that they would be held accountable to something that someone else is doing or not doing. I wonder if there would be an opportunity to just revisit that again, make sure we have it. I know what you're intending to do, but I'm wondering if it reads and if it's going to be pursued in the way that you're intending. So I have some more conversations after this.
Sure.
And am I correct in understanding that you said that part of it is in Representative Baird's bill?
No, not
Okay.
that part. No.
Okay. All right.
We've had extensive conversations with actually the associations that represent these entities. Again, the drafting attorneys has assured me that we're taken care of, but I want to make sure we get it right so there's not some undue consequences here. So
Representative.
Thank you, Madam Chair. Representative Culp, just a couple of questions. This only applies to food manufactured in Indiana? Is that correct?
no, I don't believe it's limited to Indiana manufactured.
Okay.
It's the retail in
Okay.
Indiana.
So anything coming into the state would have to have that requirement?
Right.
Okay.
When it hits the grocery shelf, yes, it would have to be labeled.
Okay. And then notice that it overrides any local health department rules. Are there any on this issue, local?
Pardon me?
Are there current local health department rules on this issue?
Well, I think that the concern here is that we're creating a state statute. And so we're not wanting there to be major differences from county to county. You could have a retail food chain establishment that is in multiple counties, and they shouldn't be having to understand which county rule they're trying to follow. And so I think that's just meant to bring consistency, that we definitely revert back to the state, and that's going to be the final say so
Okay.
on the labeling parts.
Okay, understood. And then you mentioned Representative Baird's bill. He took out the language knowingly and intentionally. You're keeping that in. Can you explain why there's the difference between those two bills?
Well, I'm not sure about what his did. So what we did, we just replaced the word recklessly. I mean, I guess that's not an identified term in code, and knowingly and intentionally is used more generally throughout the code. And we think it just adds more consistency. We think there's a better understanding of the intent and the meaning of that term versus recklessly.
Thank you.
All right. Any other questions for Representative Culp? Okay. Any committee discussion? Okay. Can we take the amendment by consent? Okay. Any discussion on the bill as amended? Representative Zimmerman,
Mr.
are you getting ready? Okay. Representative Pierce.
Oh, sorry. So I appreciate your willingness to kind of further explore the penalty section and see if we can tighten that up. I'm going to vote no for now, but I think we'll probably get to a point where I can support it on the floor. It's just I'm always yelling at people in caucus like, this came out unanimously. You're telling me all these problems with the bill. Like, what's going on here? So I'm just voting no now to suggest that there's some tweaking that could occur, and hopefully we'll get it all figured out on second.
Yes. All right. Representative Zimmerman.
Thank you, Madam Chair. Representative Culp, I'm going to support the bill. I want to explore the additional appeal process that the amendment put in the bill, but so I'd like to have further conversation about that, but I'll support the bill for today.
Can I have a motion, please?
Move to pass as amended.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
Yes.
Representative Pierce,
No.
Representative Shackelford,
Yes.
Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King,
Yes.
Representative Bartels.
Yes.
12-1.
Bill passes 12-1. Representative Sturwell, would you like to vote on 1186?
Yes, please. Record me voting aye.
Thank you. All right. Next up is House Bill 1687. Representative Schmaltz. All right, Representative Shockweiler, we're going to put you up since we can't seem to find Representative Schmaltz. So House Bill 1188.
That just means he has to vote on my bills, right? If I take his spot. Thank you, Madam Chairwoman, and thank you to the committee for hearing the bill that I'm about to present. Would you like me to explain my initial bill or as well as the amendment?
You can
kind of
put
merge
them
them
together.
together. Okay. And I might request Representative Bascom clarification assistance on the amendment as he assisted in drafting as well. So as we are considering, my bill is focused on resisting law enforcement, increasing the level of felonies for fleeing with a vehicle and fleeing with a vehicle causing bodily harm. The amendment actually resets the level 6, resets resisting law enforcement to a level 6 felony if it is committed by using a vehicle, and resets penalties enhanced originally in the bill from a level 4 to a level 5 felony. Conforms license suspension, penalties, and habitual violator status for a person convicted of resisting law enforcement by a vehicle in a manner that creates a substantial risk for bodily injury to the penalties imposed for resisting law enforcement involving the use of a motor vehicle. I might ask Representative Bascom to offer any clarifications should you have any questions on the amendment. What I'd like to thank you all for doing is holding true and to the integrity around the rebalancing of felonies in House Bill 1006 in 2013. Now that we have a decade under our belt, we have seen significant improvements in policy and statutes around law enforcement when they choose to pursue a vehicle. And in that sense, as we're looking at, the Indiana Law Enforcement Training Board implemented a uniform statewide policy establishing minimum standards for vehicle pursuits. The policy emphasizes that the risk to public safety should be the top concern. And they set the minimum standards that are adopted across the state. For House Bill 1188 as amended, why would we amend the statute? The key points to consider here are distinguishing mere operation from reckless endangerment. Under the current statute, simply operating a motor vehicle to flee in law enforcement is treated the same as operating in a way that creates a substantial risk of bodily injury to others. These should be differentiated, as fleeing in a reckless manner directly endangers the law enforcement officers and community safety. Escalation of force. Currently, it is a level 6 felony to point a firearm at someone. Yet, if an individual brandishes or uses a firearm or other deadly weapon while fleeing law enforcement, the penalty does not appropriately reflect the increased danger. There should be an enhancement consequence for introducing weapons into the act of resisting law enforcement. Injury to law enforcement officers or others. If an individual batters a law enforcement officer and causes bodily injury, it is a level 5 felony. Likewise, if someone is fleeing and causes bodily injury either to the pursuing officer or an innocent bystander, which is many times the case, it stands to reason that a level 5 felony is an appropriate charge. From a public policy standpoint, we want to encourage compliance with law enforcement. When an individual chooses to flee in a reckless and dangerous manner, they are demonstrating a clear disregard for lawful authority and public safety. Behavior that is unlikely to improve in future encounters with law enforcement, and strengthening the statute ensures that those who escalate resistance to a dangerous level face appropriate consequences. There are several folks here that can testify to the law enforcement. I would say that I am not a defense attorney. I'm not a lawyer. And I appreciate those on the committee who are and who have discussed the bill with me. And I appreciate Representative Bascom and Chairwoman McNamara for helping fine tune this to a proportional adjustment here.
Any questions for Representative Shockweiler? Okay. Representative Bascom.
No questions. I think Representative Shockweiler did a great job of explaining the bill and the amendment, so I would move the amendment.
Can we take that by consent?
Consent.
Consent.
Okay. Also on page 5 of the original bill, it was the intent to remove the level 4 felony on page 5, line 11 of the original bill. I'll do a chairman's amendment to remove the level 4 felony. Can we take that by consent?
Consent.
All right.
Thank you.
You have an amended bill.
Thank you. Thank you
Okay.
for your consideration.
All right. With that, I'll bring up Kyle Pruitt from the Indiana Chiefs Association.
Good morning, Madam Chair, members of the committee. I want to thank you for your time this morning and thank you for your continued service to our state. My name is Kyle Pruitt. I'm the Chief of Police at Plainfield Police Department, and I'm here today on behalf of the Indiana Association of Chiefs of Police in support of this bill. I know brevity is something that we always strive to achieve in these kinds of testimony opportunities and things of that nature, but I hope that you'll bear with me as I try to share why this is so vitally important in a brief case study of what has happened in the town of Plainfield just in the past couple of years. So on July 3rd, 2022, officers stop a vehicle that the driver is driving erratically, behaving strangely. They make a stop. The driver actually stops his vehicle as the officers approach and begin to engage with an individual. He continues to exhibit that erratic behavior. He doesn't produce a driver's license. When they ask him to step out of the vehicle, he then chooses to flee. Westbound out of the town of Plainfield into Putnam County, where he crosses into the median, strikes an abutment, flips his car, is ejected from the vehicle, and dies at the scene. Move to almost a year after that, June 28th, 2023, troopers from the Indiana State Police encounter a stolen vehicle in Decatur Township, Indianapolis, Indiana. They attempt to make a stop on that vehicle. That vehicle flees from them, drives northbound into Plainfield, where it does a U-turn at the intersection of Ronald Reagan and Stafford Road and begins to head back southbound on Ronald Reagan Parkway. Trooper Aaron Smith is in a position to deploy stop sticks to try to bring about a safe conclusion to this vehicle pursuit. As he is deploying the stop sticks, the suspect orients the vehicle toward him, bringing a brutal conclusion to his life and service to our state and nation. About 5 months beyond that, an officer on that same stretch of roadway attempts to make a vehicle stop. The suspect flees and within 2 miles attempts to turn into a subdivision where he does not make the turn, rolls his vehicle into a retention pond. Our officers go into that pond to try to rescue this individual. He perishes in the pond as a result of his actions. August 28th, 2024, an officer is dispatched to a local restaurant because a person saw him putting an unconscious woman in a vehicle. As he arrives at the scene to try to find out what's going on, the male subject becomes very combative with him, attempts to strike him with his vehicle, and flees the scene. Within 40 seconds, the officer in pursuit of that suspect strikes a vehicle that did not see him coming and kills 2 elderly people occupying that vehicle. And probably most tragically, last week, February 5th, officers from the Avon Police Department responding to a pattern of traffic of this stolen vehicle come down into the town of Plainfield to try to intercept a vehicle that was stolen in Indianapolis. Encounter the vehicle in about the area of Raceway Road and US 40, get into a position to try to effect a traffic stop as they're approaching Ronald Reagan Parkway. And as they turn on their lights, the suspect decides to flee. He reaches a speed of about 95 miles an hour as he's entering the intersection, striking a vehicle that is turning northbound on Ronald Reagan Parkway, causing it to immediately burst into flames, roll multiple times, and an infant, not yet 3 months old, perishes in that vehicle. The father survived with some significant injuries, and yesterday we were notified that her brother, Aries, barely 3 years old, was taken off life support, his organs harvested as a result of a convicted felon in a stolen vehicle who did not want to be held accountable for his actions. Vehicle pursuits are not Dukes of Hazzard. Vehicle pursuits are not boys being boys. vehicle pursuits are caused by the conscious decision of an individual not wanting to be held accountable for their actions. They often come with tragic consequences. After every one of these incidents, we evaluate our officers. How do they perform? Were our policies correct? Is our training doing what it should be doing? A new state law influencing the Indiana Law Enforcement Training Board's statewide policy regarding vehicle pursuits is put into place to make sure that we are doing what we're supposed to be doing. We've had a vast increase in the number of vehicle pursuits in my community. More and more, our own officers are calling off these pursuits, weighing the consequences, saying this isn't worth it at this moment. Sometimes they don't get the opportunity. Sometimes things happen way too quickly. And the reality is the penalties related to this are not significant enough. So I want to speak in support, and I will gladly answer any questions that the committee may have at this time.
Any questions, Chief Pruitt? Thank you very much.
Thank you.
Steve Luce, Indiana Sheriff's Association.
Good morning. Steve Luce, Executive Director of the Indiana Sheriff's Association. We rise in strong support of this bill. I don't have really much more to say other than what the chief, I just commend him on, what he testified about and how these situations can quickly get out of hand and cause dangerous end results in our community, not only for the people involved, suspects, families, and the officer's safety. So with that, we support the bill. Happy to answer any questions.
Any questions for Steve? All right. Thank you very much. That's all we have signed up to testify. Would you like to close?
I think I would just like to reiterate, I think if you just look at the news in your own communities, you've probably had a similar situation that as our chief and our sheriff's association have explained. And I would ask your consideration and understand that this is something that we don't ask lightly, as we want to maintain the proportionality of the level of felonies. And we appreciate that our law enforcement partners, as we all have here support our law enforcement partners, are doing their job in investing in training. And I want to give them credit in mitigating the circumstances around public safety risk in vehicle pursuits and resisting law enforcement. So thank you for your consideration and thank you for the opportunity.
Thank you very much. Any committee discussion? Okay.
Move to pass as amended.
Second.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
Yes.
Representative Pierce,
Yes.
Representative Shackelford,
Yes.
Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King,
Yes.
Representative Bartels,
Yes.
13-0.
Thank you. Bill passes 13-0. Okay. Representative Schmaltz. House Bill 1687.
Thank you, Madam Chair. Ladies and gentlemen of the committee, I certainly appreciate you taking some time to hear a bill that's very important to me in my district, House Bill 1687. Madam Chair, would you like to have me present Amendment Number 2 to begin? Amendment Number 2 is an amendment I worked conceptually with Representative Sturwald and with Representative Gore to get this bill to a good place. It changes the bill. What Amendment Number 2 does, where the bill did not, was it better defines the family member for purposes of a transfer of a sex offender. And it also includes some additional requirements for a judge to consider, and that is verified employment in the receiving county, verified living arrangements, but that does not include communal housing. So the amendment for Part 1 changes the hook that would allow somebody to move into a new community. Representative Gore may want to weigh in on the second part, and that is saying in any setting where the sexually violent predator offender against children has more than incidental or occasional contact with a child who is not accompanied by the child's parent, guardian, or custodian, or has supervisory or disciplinary power over the child, or is expected to touch a child on more than an incidental or occasional basis, would not be allowed to be employed in that situation. And I just would ask Representative Gore if that accurately depicts his intent, if that's all right with you, Madam Chair.
It does. I just mentioned this body incorporated that exact language last year into a bill. It stems from me having an offender against children on my caseload and my other job who lists his employment as karate instructor. And so I just looked into it and I discovered that we prohibit employment based on the physical location where the employment occurs, not based on the type of job that they're doing. And so this is designed to kind of fix that issue. And I really appreciate it if it would go into this bill.
All right. Why don't you go ahead and talk about the bill itself, and then we'll go with the amendment after that.
Sure. So the current situation is if one of these offenders would like to move from the supervisory county to another location, it requires a concurrence of both sending and receiving judges. What we're doing is we're increasing the scrutiny to an order issued by the receiving judge and an order issued by the sending judge, that the offender has to have a family connection as detailed in Amendment number 2. They have to have verified employment. They have to have verified living arrangements. And the reason for this is exceptionally important to me is the east side of my home county in DeKalb County, in particular, a small town called Butler, has 4 times the per capita number of sex offenders than anywhere else in my district. And we have sex offenders from across the country, frankly, but we certainly have sex offenders from across the state who are, for whatever reason, locating in DeKalb County. And it's putting an undue burden on DeKalb County Probation Services. We have to have additional probation officers. It's just generally not great for the community. I think these folks have to have a place to live. Ideally, it's where they offend, but sometimes they do have to move. And we're setting that bar just a little bit higher so that the judges shall consider these important factors when these individuals want to move into a different community. Very important to me, very important to my district, certainly very important to Butler, for us to get a handle on the number of sex offenders moving into my piece of Indiana.
All right, any questions for Representative Smaltz on the amendment or the bill itself? Okay. Can we take the amendment by consent? Consent. Okay. Thank you very much.
Thank you.
All right. We'll have Joel Winnicke.
Thank you, Madam Chair. Joel Winnicke from the Indiana Public Defender Council, and I'm here to testify in opposition to the bill. I do appreciate the movement in adjusting the list of family relatives, but I do want to talk about some concerns with due process and incentives that may be unintentionally created by this bill. For one thing, one of the primary points at which a person seeks to transfer their probation from the county of conviction to another county would be upon release from the DOC, because they want to go into a reentry program or something else that was not available in their community. Or the other reality is, with sex offenses, they may want to live in another community where the community was not aware of their sex offense. They'll be registering. That's one of the requirements. So it's not that they're trying to hide, but there was some community turmoil potentially from their conviction, or there may be a victim that they want to avoid incidental contact with. We're concerned that this is going to disincentivize counties from accepting sex offenders into their communities by requiring the judges to make this decision by written order, which then triggers public scrutiny to it. And it could create a situation where most counties throughout the state just say no new sex offenders in my community, which then forces them to live in the same communities where their victims are located. Another concern related to due process, and so there's constitutional protections for freedom of association, freedom of movement, and those types of things. I'm not sure to what extent those would apply strongly in the probation context. But the reality is there is the cure for any of those constitutional violations is the provision of due process. Well, once we've entered into this concept where we have a judicial order being issued, considering factors and these types of considerations, but there's no instruction for a petition to be filed or considered, no articulation of a right to counsel, no articulation of a hearing opportunity. I'm not sure how the receiving county especially is always going to have good information about this transfer. I would hope that probation officers would help the individuals get that information to the receiving county, but there's no process that's being defined by the statute, even though we're creating a judicial decision procedure. So those are the primary concerns. We don't want to create unintended incentives forcing these individuals to live in the communities with their victims. And we want to give individuals at least a fair opportunity to get this information to the receiving county if there's a good reason for them to move to another county, like a work project opportunity.
Any questions for Mr. Winkie? Representative Zimmerman.
Thank you, Madam Chair. Joel, is there not already a process in law where, because at least in the counties I practice, the sentencing court has to approve the transfer and the receiving court has to approve the transfer, and that order goes on the docket already. So what am I missing here, Joel?
So I think that is just a product of the language in subsection E that requires the concurrence of both courts.
We're already doing that now for any other crime, for any other offense. So what's the distinction between this and what we're already doing in courts?
Now we're building in a factor consideration of that takes an opportunity to present evidence about the relatives that live in the receiving county, the verified employment that exists in the receiving county, the verified living arrangements. And it's not detailed by statute as to how that evidentiary, that verified information is sent to the receiving county's judge, and what due process protections, if any, attached to that process of issuing an order weighing those factors.
Thank you.
Any other questions? Okay, thank you very much. Michael Harris.
Morning, Madam Chair, members of the committee. Thank you for the opportunity to testify. My name is Michael Harris, and I'm a lifelong resident of Indiana, primarily Kosciuszko and Elkhart counties. I am the director of Indiana Voices and a board member of Indiana Cure. Indiana Voices represents those people who are required in Indiana to register as sex offenders, which includes a number of juvenile sex offenders themselves. Around 307 male juvenile offenders and 47 female juvenile offenders. We rise in opposition to this bill. It seems a bill aimed at keeping registrants from going to counties where services are available. Butler County in particular has a very fine program that helps offenders re-enter the community. It's a recovery program, and I believe that is the reason why there are so many offenders coming to Butler County or Butler, Indiana, because that is one place where those kind of resources are available to people who have been convicted of sex offenses. Of course, registrants are going to gravitate toward communities where they can find services. As we continue to impose additional restrictions on housing and employment, it is necessary for people to be able to move in order to accommodate those needs. Otherwise, they're stuck with housing from slumlords or substandard housing in other counties or the county where they live, or maybe no housing at all. The living arrangements in Marion County, for example, with all of the restrictions, make it very difficult for somebody to find housing within the city of Indianapolis. So as we continue to impose these restrictions with no evidence, in fact, the body of evidence shows that proximity does not engender offense. And as we continue to put these banishment areas, offenders need to move to different places where they are able to find housing, employment, and appropriate associations and support, including the program in Butler, Indiana. I'm part of a board of directors of another recovery hub in Kosciuszko County, and we're having an influx of people come into Kosciuszko County as this recovery hub helps people recover from alcohol addiction and other addictions, as well as accepting people who have been convicted of sexual offenses. As regards the amendment to the bill, which I just became aware of today, which further restricts employment for people convicted of a sexual offense. The problem with most of these bills and most of these additions is that they're based around this created title that we have come up with of offender against children and sexually violent predator. When the legislature changed the criteria for offenders against children and sexually violent predators from a evidence-based designation to a strictly offense-based designation, it took away all evaluation of those people in order to actually guarantee that that particular designation actually represents somebody who is dangerous to the community. It does not currently as it stands. And so for these reasons, I would ask you to, instead of considering bills like this, to consider bills that are actually going to have much more impact on keeping people safe and keeping people from sexual offenses, such as trying to provide mental health services prior to offense, increasing employment and housing opportunities rather than decreasing them, and increasing opportunities for programs such as the one in Butler to happen. I mean, you could spend $1 million and go out and create a program and then have something like this happen and shut your program down tomorrow. So it takes the incentive away from people that are trying to create such programs. So I urge you to oppose the bill on those for those reasons, and I'm happy to answer any questions you might have.
Representative Bauer.
Thank you, Madam Chair. Thank you for your testimony. I just have a couple questions for the individuals you're speaking of who are moving to Butler. Do the majority of them have living arrangements or work lined up as well?
Well, the living arrangement is in the program. It's a
Okay.
residential program.
So that could possibly be one of the exemptions that's included in this bill?
Well, the way the bill is constituted, it excludes those programs. It says you can't move to those counties for those reasons.
Okay.
You can't
Is
move
it-
there unless there's a relative, you have verified employment and whatever, but it excludes coming to a program, a group housing, or however, I forget how.
Okay, it says verified living arrangements, not including a communal housing arrangement, and that it's be communal housing.
Exactly.
Okay. Possibly, maybe one of the exemptions we could add would be or seeking recovery or treatment. Would that be?
Yeah, it's not going to accomplish what he wants to accomplish with the bill, but yes.
Okay.
That was certainly.
Okay, thank you.
Mhm.
Representative Sturwell.
Yeah, what's the name of that program in Butler?
Shoot, he probably knows better than I do. I can get that to you. I can't, it's not on the top of my head right now, but I can let you know. I just need to look at my phone real quick before I leave here.
And just to make sure I understand your testimony, you're opposed to the bill, but you're not opposed to the amendment that says somebody who has been convicted of this offense that has propensity to be attracted to young people. You're not opposed to that part of the bill that says you can't have any more than incidental contact, are you?
Yes.
You're opposed to that?
Yes. Because it further limits employment and also proximity laws do not have anything to do, according to the finest experts in our country, with sex offense. Also, the Indiana Department of Correction lists sex offense at 1.05% reoffense rate. So it really is an irrelevant.
I'm not talking about physical location. I'm talking about someone who has a propensity, has been convicted of child molesting, that now is employed where they have more than incidental physical conduct with a young person.
Well,
so let me ask my question.
Sorry.
Are you opposed to that part of the amendment?
Yes, because it further limits employment, and I don't think it's specific. That would include McDonald's potentially. That would include any.
No, it's beyond incidental physical contact. This is people in karate classes that have continual physical contact. That's all the questions I have.
All right, thank you.
This program in DeKalb, do they advertise across the state and want people to come into their community?
Well, I imagine just like any business, there is some degree of advertising. I know they have a website. I know they have people who know, but I think it's largely word of mouth.
And do they bring in people from out of state?
The program is open to people from out of state, as I understand it. But in talking to the man who runs the program, I believe the majority of their residents are Indiana residents.
So they're targeting people from in the state and out of state to come to DeKalb for the program. For what type of services of rehab do they do at this particular location that is a draw?
Well, they have housing for number one. Number two, they have employment requirements for those people in the program. They have recovery type programs, instruction, and I mean, it's a laid out program that has a daily schedule that these people must follow.
How long are they in the program for?
I think that varies depending on a number of factors that I'm not totally aware of.
Are the out-of-state residents actually being put on a sex offender registry in the state of Indiana?
I'm sure they are, otherwise they're violating the law. I mean, they would be required to do that, and I'm sure that the program would not allow them to be in the program without that. It's not my program, so I can't speak totally to their program. I'm just aware of the program.
Okay, thank you very much. Any other questions? All right, thank you very much.
You're welcome.
Representative Smaltz, nobody else has signed up to testify if you'd like to close.
Thank you. Just like to respond to a couple of things. I have great faith in the courts to look at a situation for an offender when it comes to relocating. I have great faith in the courts to make a decision that's in the best interest of the community, of the offender. We want them to get better. They have to be somewhere. They have to work somewhere. So a lot of that gets left up to the courts. And I really want to point out that I think the previous witness underscores my point, is that there is an active program in Butler, Indiana, that is recruiting sex offenders, according to the previous witness, from in-state and from out of state to relocate into Butler. Butler is about 2,500 people, by the way. It's a very, very small community. This bill makes a big difference, certainly to the people of Butler, Indiana, but there have to be other Butler, Indianas across the state that are facing this exact same sort of problem. They need to have more control over who's coming into their communities, the burdens that are being placed on their courts and their probation departments for the safety of the people who live there. And I really would appreciate your support on 1687 as amended.
Thank you very much. Any committee discussion? Representative Gore.
Thank you, Madam Chair. In my county, Marion County, we have over 1,800 registered sexual or violent predators. By far the most. I mean, it makes sense, we're the largest county. But distressingly, when I started my career, about 40% of them were from out of county, sentenced from out of county. Now, the majority of them are sentenced from out of county. When last I checked, it was about 52% of them. And it's true that we have programs in place for these folks. We finally, in a bipartisan manner, ended the practice of DOC dumping people in Marion County without a housing plan or an employment plan language that I think is mostly mirrored in this bill, which I appreciate. But we continue to have to ask ourselves why there are so many folks from out of county moving into select locations. And this gets us on the track to kind of study that and be able to recognize why that's occurring and limit certain instances of that. And so I really appreciate the effort. And then I just want to thank the committee again for adopting these reasonable measures surrounding employment. I think, just a reading of the black and white text makes sense to a lot of people. I also want to mention that it says more than incidental or occasional contact in an environment where the person's parent or guardian is not. Right. So when you're talking about McDonald's, I guess you can send a kid into McDonald's, but that'd be incidental or occasional. We're talking about a prolonged contact with a minor where there's no guardian. So, grateful for that to have been included.
Any other, Representative Bauer?
Thank you, Madam Chair. I just wanted to clarify with the language of the amendment, maybe this is to Representative Gore. So you're addressing employment of sexual predators committed of crimes against children, not necessarily crimes against adults in that employment language?
Let me look real quick just to confirm, please. It's both.
It is both.
Thank you.
Distinction is violent predator. So your regular sexual offender.
Or
I hate to use the word
against
regular, but it's not included. All right. Any other comments? All right. We have an amended bill. Can I have a motion, please?
Move to pass as amended.
Second.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer.
If I may briefly explain, I understand that many people are moving for services. My community is probably one that does provide a lot of services. I think maybe we could look at adding in exemptions for people who are seeking treatment, and if the recidivism rate is very low, then maybe we should hear that. But at this time, I will be a yes to move it along, and hopefully we can make sure everyone's covered in this.
Representative Pierce,
Yes.
Representative Shackelford.
I just want to explain my vote. There is a piece in here that concerns me that's kind of broad when we just say more than incidental and occasional contact with a child. Because I think we had the same debate last year that if we have an offender working in a McDonald's, working next to minors. And so that's where it gets kind of murky right here. I'm all for B and C, but I think when you have A, that we will be limiting where these offenders can work at. I think it is going to be a big impact. So I would like to see us work on this maybe before it gets to seconds, or if we can get some clarification, but I'll be a yes for now.
Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter,
Yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King,
Yes.
Representative Bartels.
Yes.
13-0.
Bill passes 13-0.
Thank you, Madam Chair. Thank you, committee.
Can we get it over to you?
Thank you, Madam Chair. The final bill on our list is House Bill 1119, Representative McNamara.
Thank you, members of the committee, Madam Chair. House Bill 1119 is a bill that I've worked on over the last 2 years with Dr. Malin Hustis. She's a world-renowned expert on human drug testing, and her research focuses on the effects of occasional and frequent cannabinoid use on pregnancy and child outcomes, brain function, and driving impairment, and on novel psychoactive substances and synthetic cannabinoids. HB 1119 is based on the work product of those conversations. I do have an amendment number 2 that takes the bill and makes it very specific to what it does on using qualified tests. If it pleases the chair, may I speak to the amendment?
Please do.
That's the, okay. So amendment number 2 defines what a qualified test is for purposes of oil fluid. It specifically designates the Draeger 5000 or Sotoxa roadside oral fluid tests. Both of these tests have been recommended by toxicologists. Currently, Sotoxa units are used and available to Indiana law enforcement through Indiana criminal justice grants. So several communities already have Sotoxa available and do use them. In addition to the THC, these devices can screen for several drugs and drug categories like meth, amphetamines, cocaine, opiates, and benzodiazepines. The TCH cutoff for both Sotoxa and Draeger 5000, if anybody on a Draeger 5000 has 5 nanograms or less, it will show a negative result. And then a Sotoxa, it is a little bit higher at 25. Again, anybody who's testing positive will test above that particular thing. You cannot manipulate these to change the quantity. So it's going to be on that particular level of amount, and it can't be alterated. It's important to note, and this was in the bill as well, that law enforcement may not arrest a person solely because they test positive on the qualified tests. It does allow the introduction of the results from these devices as a relevant evidence so that the jury may decide how to put weight on the positive results. The final section of the bill and the amendment is to lessen the burden of the state lab and the Department of Toxicology. Currently, our labs are suffering from backlogs that resulted in delayed trials, as well as significant money going out of state from our Indiana Criminal Justice Institute to Department of Toxicology outside the state of Indiana. It allows for the defense attorney, if they do not request the presence of the lab technician, the defense will waive their right to cross-examination, which is current law, and it'll stipulate the omission of the report. This part's new. And if they do, they will allow a lab technician to do it via video appearance, unless, of course, there's a request for in-present testimony. I think this is the next horizon, the next step in how we test for impairment in the state of Indiana, while making sure that there's some reliability around that. So with that, I'll take any questions.
Are there any questions with regards to the amendment? Representative Pierce.
Yeah, I'm just wondering, is the Draeger Drug Test 5000 like a brand name of a particular manufacturer or a more generic description of a kind of a testing machine?
It's a brand name. So what we try, so in formulating this bill, talk to world-renowned toxicologist Marilyn Hustis. I tried to get her here to testify today, but she's expensive and on vacation. But this one is by far the one that's recommended more than any other for its reliability and efficacy, even though Representative King didn't want me to use that word. But if you look at I forwarded to your emails frequently asked questions about oral fluid use. There's a dozen or so websites, but you can look at the testing in comparison to other types of oral fluid testing, and Draeger by far is #1 recommended. So we included that. But I also included Sotoxa, which its reliability is up there just as much, because the Indiana Criminal Justice Institute has already put those out for our law enforcement to use.
Okay, because the reason why I just raised the issue is I remember that we had a bill on vape testing or something, and that became a little bit of a controversy because apparently there was only one manufacturer could do it. And so I'm wondering how we might deal with the situation as this technology matures or other people enter the field. Will we just have to come back and amend the statute later if there are other equally effective testing machines?
I'm just looking for consistency. If you're going to do this, you want to make sure from county to county that you at least have some consistency. If technology changes, and we actually in the original bill considered just writing technology, but I think for a toxicologist perspective, because they're going to be one doing the analysis and looking at that sort of thing. Consistency is the key right now since it's new. So it's, I think, important to designate one or the other to be used so we can establish a baseline of consistency.
Any other questions from the committee? Representative Jeter.
Yeah, I'm just curious. So is the idea to get this test like in the field, because it says law enforcement officer may not arrest a person solely because the person tested positive on the test. So are you just trying to kind of get it into the field and see how it all works? Is that kind of the goal?
It's already in the field.
Okay.
Okay. It's just not used as relevant evidence, and this will include it as that.
So you'd have to also see actual physical evidence of impairment?
Correct.
Okay,
And
gotcha.
then blood tests if necessary.
Any other questions of the committee? Can we take the amendment by consent? Thank you. You have an amended bill, Representative McNamara.
Can you see me?
Chris Daniels from IPAC.
Thank you, Madam Vice Chair, members of the committee. My name is Chris Daniels. I'm the Senior Traffic Safety Resource Prosecutor with the Indiana Prosecuting Attorneys Council. I wanted to thank Representative McNamara for her work on this bill. Obviously, impaired driving enforcement is a major issue in every state across the country. And right now with the drug epidemic that we have in a variety of forms, whether it's the opioid epidemic, meth, prescription drug abuse, what have you, drug driving is an increasing problem that's costing more and more lives across the country and in the state. Oral fluid is a major step toward enhancing our ability to enforce our impaired driving laws. Not only is it good as an enforcement mechanism, it also saves time, it saves money, and ultimately will result in less government intrusion when we stop having the same reliance on blood tests that we have now. This bill is a very important first step in going there when we're looking at these tests. These tests are screening tests. They're tests that are used in oral fluid programs in New York, in Alabama, and in Minnesota. In fact, in all three of these states, both of these devices are used. I believe New York uses two other devices as well, but those are manufacturers that are out of the country. I believe one is in Europe and one is in Australia. So, there are a variety of these programs. We do have some states that have moved on toward doing confirmatory oral fluid testing that would be able to use the same way that we use our blood test now. Our Department of Toxicology isn't that would be a multi-year plan and a significant fiscal to do that. But this really puts us ahead of the curve in terms of enforcement by putting us ahead of where a lot of other states are. We would be using this as relevant evidence. So going to the point raised before, we would not be using these results alone to determine a conviction. We would still have to prove that somebody was intoxicated under that statute, or we would still have to prove that the substance was in somebody's blood. But having that oral fluid result come in would help bolster those results. The second part of the bill would significantly help the Department of Toxicology. Several years ago, the notice and demand statute was passed that the intent was to stop the people from the lab from having to travel to court as much as they did. However, it only really waived the right to cross-examination, not the foundation aspect. So that's why the language that puts the stipulation to the report in here. Speaking with the Department of Toxicology, there's so much of the time that they waste traveling in order to testify. And what happens more often than not is the defense attorney is just waiting to see if the state's witness was going to show up, and then they either stipulate or plead or the case gets continued. And speaking with the director of the Department of Toxicology, they said so far this year, just for this year, and we're obviously in the beginning of February, they logged the hours that they've spent traveling and testifying, and they've spent 75 hours traveling and 5 hours testifying. And so what this does, and then those analysts are out of the lab, they can't do the work, the backlog grows, and the state has to pay to farm that stuff out to the NMS laboratories who still do a lot of the testing that comes in. By allowing for that video testimony, you're giving courts the permission to use the video system for these analysts that are typically used solely for foundation purposes for the admission of a lab report. It also still allows for the defense attorney to cross-examine that person just via video, and allows them to go before the court and say that they believe that person needs to be there if they're testifying to anything other than or even if they are just testifying to the foundation, and it's still anticipated that if a witness was going to testify to something beyond that, they would still have to show up in court. So greatly appreciate the work on this bill. Like I said, I believe it will help bolster our impaired driving enforcement. It will save time and money and really put Indiana kind of on the cutting edge. But with that, I'm willing to take any questions.
Questions? Representative Jeter.
Thank you, Madam Chair. Two questions for you, Chris.
Yeah.
Number one is this bill, you correct me if I'm wrong, this bill has absolutely nothing to do with the charge of possession.
Correct.
So you pull somebody over before you do any of this, if there's marijuana in that car, you automatically have a possession charge.
Correct.
So that you could, if you decide to. Okay.
Yes.
The second thing is I always get a little nervous about putting in law like the admissibility of evidence and stuff, because obviously, and I know you would agree with me, I mean, if the lab's overburdened, I mean, that's not a criminal defendant's problem.
Right.
You know, and if they want to demand the evidence be presented, then they should be able to demand the evidence be presented. I mean, it doesn't really matter if the lab person spends 1,000 hours in the car. So I'm a little bit, I don't love that, but I do think maybe there's some safeguards in here, but I want to confirm. So it says that the defendant must file a demand for the person's appearance not later than 10 days after the defendant receives the notice in Section 2. When would that notice normally be provided to a criminal defendant? I assume it's not on scene, right?
No.
You got to test it.
This is when the state files their notice of their intent to introduce the laboratory reports. That takes an affirmative filing by the state that they file these under the statute number saying the state intends to introduce this blood result. We have to file that with the court under the statute number, and then obviously the defense gets served with the state's file.
So that would be well after counsel's been
correct,
appointed or retained,
Yes.
right? Okay.
Yeah.
Just want to make sure. Thank you.
And that's current law. It just currently only addresses confrontation, not confrontation and admissibility.
Any other questions? Representative King.
Thank you, Chairwoman. Chris, thanks for being here today. Are you concerned at all of false positives when we're doing testing like this? The reason I'm asking is I've looked at some of the efficacies of these tests, and I want to make sure that when we're using this, that we're not creating a problem for someone, or a school bus driver, or someone that it would involve their employment when it's an issue with the false positive.
Of course, and that was actually part of the discussion in this bill. That's why we don't have it in there as prima facie evidence that just says we assume you're guilty unless you can prove otherwise. This is only in there as relevant evidence, which means the jury can consider that there are false positives. There's a reason why these screening tests aren't used as confirmatory tests in other states that have these programs. They're not used as confirmatory tests in labs because of that risk. So this puts it at a spot where it is relevant, where we can bring it up in court, but a defense attorney can point out there is the chance for false positives. Where I see this really being used is when you're in a spot where, like I said before, we still do have to prove that they were either intoxicated or that the substance was in their blood. So you won't have, for example, a bus driver who, let's say, pops positive and it's a false positive because they're actually totally fine. Well, then they would have nothing in their blood and be showing no signs of intoxication. We'd have no charge to go forward on. So this is just to assist the current structure that we currently have. We would never be able to rely solely on that. And that is because oral fluid is still kind of an emerging science, why we only have a few states with confirmatory programs, but that was definitely considered for that very reason.
Any other questions of the committee? Thank you, Mr. Daniels.
Thank you.
Mr. Michael Moore.
Morning. Michael Moore, the Indiana Public Defender Council. I apologize. I signed up for support, but given the amendment, we now oppose the bill. And so I had to quickly put together some notes. I'm going to be a little bit all over the place with this. As I said, we were prepared to support the bill because we thought this was a positive move, at least establishing some threshold for the per se law. In Indiana, if you're not familiar with this, we have what's called a per se operating. So if you're operating while you're impaired, either through alcohol or drugs, you could be charged with that crime. But you can also be charged with the presence of either alcohol or drugs in your system. So for alcohol, there's a certain threshold of a BAC of 0.08. But with marijuana, there isn't one. It's just if you have marijuana in your system, positive or negative. If you used it a week ago, yesterday, or this morning on the way here, it's positive, it's a per se conviction. We don't care about the amount. We also don't care if you're impaired anyway. The BAC is different because science has demonstrated that when you have a 0.08 amount of alcohol in your blood, that there's a strong likelihood that you'll be impaired to reliability. But with the THC, we just don't have that, unfortunately. So we just have a strict If you're positive, you're positive. If you're negative, you're not. So that's where this concern comes from, because we don't have real protections for people who are not impaired in any way by the use of marijuana, but they're driving. Ironically, we do have a defense available to people who test positive for THC in their system while they're driving if the result of the operating is serious bodily injury or death. The defendant can raise that as a defense, and then the state has the burden to disprove it beyond a reasonable doubt. But we don't have that same defense when it comes to your everyday driving. You're driving to Michigan for a weekend, you use because it's legally, you come back home, you get pulled over in one of the border states or border counties. You've got THC in your system that now will be through a portable test done roadside. The reliability of which we don't know. I mean, I've heard some good evidence that it is reliable, but obviously there's going to be litigation about that as these cases move forward, with defense attorneys questioning more and finding out more about these tests and their reliability and other factors that may impair their use. For example, we used to have a PBT test, we still do, but there was always concerns about radio frequencies and cell phones and other contaminants that could affect their reliability. That's why we don't let those be admissible into evidence in DUI cases. That's just a test to determine whether or not there's probable cause to go further to conduct filter body tests and maybe a chemical test, but we don't make them admissible. They're the results of which. I want to thank Representative Jeter for your question, because that's the big concern we have, is that these tests, which are not laboratory with confirmation with a witness who can testify about the foundational requirements of these tests, is never going to be there. It's just a positive or negative. It doesn't prove the case, but it's certainly, we have a per se case. It's the only evidence of drug use without any evidence of actual impairment or intoxication. So we have real concerns about that and the fairness. Admissibility means that the foundation requirements are there for the non-lawyers. Foundations just are the steps to show that this evidence is what it is, it's reliable, and it can be considered by you for guilt or innocence. The other parts of the test are the results accurate? So there's two prongs to evidence when something comes to evidence. And so this would bypass both of those. The law would say foundationally these are admissible, and the results of which you may consider for guilt or innocence. That's our concern. We don't weigh in on whether or not you should use one brand or another. That's for other people to talk about. But we want to really encourage this body to consider modifying the defense that currently exists in law for operating with THC in your system, and that involves a crash that has bodily injury or death, and extend that to the same operation of vehicle, the same behaviors for those who are just driving. And because the officer had a hunch, either the smell, or usually the person admits to having smoked previously, is taken down for a blood draw, and then suddenly they're facing a DUI, even though there's no evidence of any impairment. So I think that's really important for this consideration, because what we're talking about, even though they can't make an arrest for a positive result on these two tests, they can still charge. And the person can be brought to court, have to answer and suffer a punishment. And these test results will come in without any real evidence to refute it, because the foundational requirements are bypassed, as are the results. So we have some concerns. We'd like to see more discussion, more consideration of this, but we do oppose the bill. I apologize because I signed up for support, but.
Any questions from the committee? Representative Bauer.
Thank you, Madam Chair. Just one question. Currently, are there individuals who have been charged just because there's been a presence of smoke when they were pulled over?
Oh, yeah, all the time.
Or perhaps they...
Well, I should say that was then questions were asked and that kind of thing, and they were taken down someplace, had a blood draw, a positive result happened, and then they were charged.
Or even if they, as you, in your example, where they go to Michigan, come back and they're charged with possession or some sort of...
Well, they get pulled over. Maybe possession is kind of a different topic, but if they're pulled over, they tell the officer where they've been and what they've been doing. Okay, now I have reasonable suspicion. Will you consent to a test? Yes. We don't give them the same advisements we normally would for an alcohol test, but hey, we would come down and get your blood drawn. Yes, I will. Or I admit to it. And then the person is charged. It's a common complaint amongst the defense bar, now all the border counties, because there's legalization of some form in every county that surrounds us. And so people are coming and going. That's where we're hearing the most complaints are. Why are we charging and convicting people for just having in their system without any evidence that they're impaired? And that's a real problem. Ironically, if there were an accident that resulted in bodily injury or death, they could raise that defense, but not just driving home from Michigan from a weekend.
So as the original bill was, remove some of those charges for individuals who were not driving intoxicated, but might have something in their system, but with the amended version, it may not be catching those individuals.
Yeah, the original bill, it was moving in that direction. It was the same test, the oral swab test with the saliva test. And it would allow for the charge to be charged if there was a 0.50 result. But we've heard today that test doesn't do that. But there is a threshold. So if it tests positive, that means the test knows there's at least that or more. And we don't like thresholds either, but at least it's something. We need a threshold of some kind. We would prefer it to be intoxication, evidence of intoxication. Just get rid of the per se statute altogether. But if they're going to keep the per se statute, some threshold like 5 nanograms is what oftentimes is used, and these tests, that's what they use. Would have been a move in the right direction, if that makes sense. It's a complicated, confusing answer. I apologize, but
Any other questions from the committee? Representative McNamara.
So you're in favor of adding back in at least the 5 nanograms of THC that was in the original bill?
at least some threshold. Yeah, I know it's not scientific.
So I guess my question is,
Yeah.
it's not scientific, right?
Right.
You can't get your experts anywhere to agree to what is impairment. So I'm
Agreed.
trying to figure out what the advantages of having that in there when the community that researches this can't come to a conclusion that somebody actually is compared at 5. You know, if you're a chronic user, heck, they might be like an alcoholic that at 1.5 is a functioning alcoholic.
Yeah.
So how does putting that limit in there, and my thinking is, okay, we got the Draeger 5000 that tests positive at 5. Okay. That's
Yeah.
automatically setting that threshold without saying it. Does that make
Right.
sense?
Yeah.
So why would we want to put in statute 5 nanograms when we know that we might have somebody that is not impaired at 25?
Yeah.
Does that make sense?
It does, yeah, and we wrestle with that as well, thinking through this. The Draeger and the other tests, as I mentioned, there are the question that really goes to their admissibility. They're coming in with no legal bar. I mean, the bar's pretty low to get evidence in. There's foundation, and then the other parts of the foundation requirements get evidence in. Now we're just completely removing it altogether. The threshold was, I agree, the science doesn't support it. But it'll at least have been a number. We prefer to get rid of the per se altogether because the per se is problematic since there's no requirement that any impairment ever be proven. So that's our strongest preference. Our second recommendation would be to bring that defense that already exists into just the normal operating with the THC in your body. Third would be some threshold. So if we had to prioritize, it would be in that level.
Your preference is only to remove the per se for THC, not for alcohol,
Correct.
correct?
Yeah, because there's good science on the alcohol. The BAC 0.08, that establishes that is a threshold. There's a reason for that. But yeah, we would just say THC only.
Any other questions of the committee? Seeing none, thank you, Mr. Moore.
Thank you.
That was the last person that we had signed up to testify. Representative McNamara, would you like to close?
THC is probably one of the trickiest things I've ever tried to nail down and having conversations with folks. And there's 2 things I'm trying to do with this bill. Number one, give the state of Indiana the opportunity to figure out who our impaired drivers are, right? And being able to do that through the qualified tests that people are already using on the streets today gets us to that point. And it's also the recommendation of toxicologists to do so. And I'm open to having continued discussions about what this looks like, but oral fluids are the future of testing. They're the least intrusive. If you have about 20 hours in your life, there's plenty of research to drill down on. I sent you a couple of frequently asked questions and that sort of thing. But I think this is a first step in really trying to get a handle on what this looks like in the state of Indiana. And, you know, I think the part for me that I think is important is the fact that if you are a negative tester, you're a negative tester, right? And we don't have that option here in the state. And for me, that's what is important there as well. But with that, I just appreciate your support.
Thank you. Discussion of the committee. Representative Pierce.
Thank you, Madam Chairwoman. I'm interested in supporting this bill because anytime you discuss the issue of whether or not we should join the other states that have legalized cannabis, kind of the first thing you hear is like, oh, we're going to have all these impaired drivers and there's no way to really test them or prove they're impaired. And it's going to be, mayhem everywhere. And so I think if we had some system we could point to on the impairment, that would maybe deal with that issue. And then you could get on the other policy, debates surrounding legalization. So I think that would be a positive step forward. I have to admit, being someone who's never practiced defense law, I do have a little bit of pause about some admissibility issues that was raised by the public defenders, but I admit that I don't understand it well enough to draw an opinion on that. So perhaps as the bill moves along, that could be something that could be, further explored as to how we can achieve your policy goal with that section while ensuring everyone's got the due process that we need there. Because I think that, one, you might challenge whether the test was properly administered and the chain of custody of the results or all that kind of good stuff. And then on top of that, since this is such new technology, I'm assuming you might challenge the technology itself and say that it really doesn't measure what it claims to, or it's not accurate or something. And so I think as long as you can ensure that those kinds of things can be raised at trial, that would be good things. So I don't know if our bill's inadvertently precluding that or not. We'll just have to find out as we go along. But I do think it would be positive to have something we could point to saying that, yes, we do have a test now to begin to deal with impairment.
Further discussion? Representative Zimmerman.
Thank you, Madam Chair. I'm going to support the bill. I have concerns with certainly the admissibility, the stipulating the admissibility of the report, but also I have confrontation clause concerns about to me, the amendment reads that it's almost a presumption that the lab tech will appear by video unless the court finds otherwise, and I think it should be the reverse. But I'm going to support the bill, but I want to continue exploring that as the bill moves forward.
Any further discussion? Seeing none, will of the committee?
Move to pass as amended.
Take the roll, please.
Representative McNamara,
Yes.
Representative Gore,
Yes.
Representative Bauer,
If I can explain, I'll support the bill today. I do want to make sure we are targeting operating while intoxicated, not just identifying people who are users or using. But for now, to move it forward, I'm a yes.
Representative Pierce,
Yes.
Representative Shackelford,
Yes.
Representative Meltzer,
Yes.
Representative Zimmerman,
Yes.
Representative Ireland,
Yes.
Representative Jeter.
Yeah, I have some issues about the admissibility portion as well, but I trust the author to keep working the system. So I'm a yes.
Representative Bascom,
Yes.
Representative Sturwald,
Yes.
Representative King.
I have some issues with this, and probably the biggest thing is I started going down the rabbit hole of reading all the stuff on this, all the products that are available. I think there's like 9 different products that are available in different countries. None of them have shown the sensitivity, all the things that are required by like the Druid report to make sure that we use this. I'm concerned about false positives. I'm concerned about people being, and I realize that was explained well to me, what we can and can't do. I'm concerned about this. And yet I understand where our police officers, when they have to make decisions, field sobriety and whatnot, they need to have, here we go, tools in their toolbox. I've heard that several times this session. But I just think this needs a longer, deeper look. I don't think this is prime time ready yet. And I'd love to support the bill, but I'm not going to at this point. Thank you.
Representative Bartels,
Yes.
12-1.
12-1, the bill passes. Congratulations, Representative McNamara.
Thank you. All right. This is our last meeting for the first half. We will reconvene here for the second half. We are adjourned.